So I want to shoot a real short video today to talk about fee agreements. I've had a couple clients approach me, ask me to look at their fee agreements because they were concerned that they weren't getting as much money from a particular case, a settlement, or a verdict that they was favorable in their case. And a lot of times they just don't understand how the fee agreements work. So I really just kind of wanted to cover some basics today, keep it really short. You really have kind of four different types of agreements. You have a flat fee agreement, you have a contingency fee agreement, a retainer fee agreement, or maybe a hybrid. And I'll explain quickly what those are. A flat fee agreement is just an agreement between you and an attorney where they're going to do the work for you, and it's just going to be at a flat rate. And it may be that they file a patent for you and it's a flat rate. It may be that they do a simple will for you and they charge you $500 and it's a flat rate. If the work takes him an hour, it's an hour. If it takes him a couple hours or even a day or a couple days for him to complete the work for you, it's still only $500. And the advantage is it's a fixed rate. It's a fixed price. So you know exactly how much you're paying for that legal service. A contingency fee agreement is an agreement where the attorney typically takes the case. They pay all the upfront costs, the filing fees. They'll pay for sometimes an investigator in a particular case. They'll pay all these fees up front, file a lawsuit for you, and then if the case settles or it goes to trial and you receive a favorable verdict, then the attorney gets their percentage out of the case, and then they also get their costs. And then they also, if you have any kind of lien on the case, sometimes you might have a medical lien if you went to see a doctor or you had x-rays done where you didn't pay for it out of pocket, there's going to be a lien on the case, and then those people are going to get paid out of your settlement. And so if it was a simple car accident case for $10,000, the attorney's going to get 33% to sometimes 40% on a particular case plus their costs. So they're going to get between $3,300 to $4,000 out of it, plus their expenses. And then if you saw some chiropractors, if you saw a doctor, if you went to the ER, all those costs would come out of that settlement, depending on whether or not your insurance was involved. And then whatever was left over would go to you. And so it's not uncommon on a $10,000 case, you might only see $3,000 out of the settlement. And sometimes clients are upset about that, but you have to understand what kind of fee agreement that you're signing with your attorney. You also have just a regular retainer agreement. Maybe you hire an attorney to represent you in a DUI case. He charges you a $5,000 retainer. He bills at $300 an hour. He puts 10 hours on your case. The case is done. Maybe he gets a plea, negotiates a plea for you, and he would bill you the $3,000 for the work that he did. If there was no other expenses, then you would receive the other $2,000 back. But if he billed 20 hours on your case, then you're looking at him using up all the retainer, and then you would have a $1,000 bill left over with the attorney to settle out the case, to settle out your bill with the case. Then finally, there's a hybrid. A hybrid agreement might be something where you hire an attorney to represent you in a criminal case. So you would have a $5,000 retainer, but then after the criminal case settles, you would have an agreement with the attorney to maybe file a civil case on your behalf. And that would be under a contingency fee agreement. So it's important that you know the types of agreements and identify those. And what I recommend to attorneys is that you spend extra time explaining those to your client. And then I recommend, if you're the client, you spend extra time reading the attorney fee agreement and understanding it. And then for attorneys, something I recommend is put some hypotheticals in your agreement. So put a hypothetical, for example, hypothetical A is this, and this is how much it would be in fees and costs. Hypothetical example B would be this, and this is what it would end up being with fees and costs. So the client has some sense of what the expectations are, and then just keep them informed as you go through the litigation, as you're completing the legal work for them, so they know and they have some idea, and they're not kind of shocked at the end that they aren't getting what they expected out of the case. All right.